Since they swore oaths to uphold the Constitution, these judges and chancellor members are in violation of their oaths of office, and they are in treason to the Constitution.
We will go back to the item number 1, the Board of Judicial Conduct. Is anyone here from the board? Board of Judicial Conduct. Anyone here from the board? Senator Bell, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, I am going to take partial blame for them not being here. If you remember last year when we reconstituted the board, and in that reconstitution, you've got a lot of new members. We've got a chair who's not a brand new chair, but he's in his, I think, first year. He had already been serving as chair. We did send a notice to him, but he just didn't understand the notice and is not here. I've been texting him. He apologizes for not being here, and he said it was not intentional. In looking at the rule, it is an emergency rule. It went into effect on 10/7. It's in effect for 180 days, which I think puts it through 4/4. That it's in effect for, regardless of what this committee does. But statutorily, they're still supposed to be here to present the rules. So my motion is that we roll this to our next scheduled rule review meeting, which is the date. Have we got a date for that next meeting yet?
Not confirmed yet.
Okay. Well, my motion is that we move this to our next scheduled rule review meeting. Will it be in January?
Yes.
Okay, our next scheduled rule review meeting in January.
Thank you, Senator. Do we have a second on the motion? Okay, before we take a vote on that, we do have a member of the public here who would like to speak on this. I appreciate you coming down, taking the trouble of coming down. Would you like to speak given the fact that the presenter is not here?
I would very much like to.
Okay, please step forward and introduce yourself, and please, you have 5 minutes, please.
Yes, Mr. Chairman?
Yes.
There is a motion on the table. I made a motion, and I think I heard a second on that motion. And that does cut off all debate and all discussion on the rule. Now, as I understand the rules, the chairman can ask me to withdraw the motion. But there is a motion on the table.
You're right, Senator, and I apologize for that.
Okay.
Would you care to withdraw the motion?
Mr. Chairman, I would prefer to take up the gentleman's discussion when the board is actually here and we're discussing the rules. In light of that, I'm going to respectfully decline to withdraw my motion.
Understood. Thank you, Senator Bell. What is your name, sir?
My name is John Anthony Gentry, and I would like to assert my right under Article 1, Section 23, to address the powers of the government.
Yeah, wait just a minute.
Violated
Mr. Gentry,
whatever.
Okay, wait just a minute, please, okay? Okay, we do have a motion, Mr. Gentry. Our procedure requires that we take a vote on the motion before we hear from you. The presenter, is my understanding, will be here in January if you do not get a chance to speak tonight. So we will hear discussion on the motion. Would anyone on the committee care to discuss the motion? Representative Hardaway.
Thank you, Mr. Chairman. And just for clarification, if the motion fails, is the gentleman that wants to testify automatically entitled to be heard, or would there need to be another motion?
Counsel, would you care to respond?
Doug Gare with the Office of Legal Services. Thanks, Mr. Chairman. I don't think that there would be another motion necessary to allow the gentleman to speak unless there's some division as to that possibility. Certainly, he could be encouraged to come back again at the next rule review meeting if he wants to speak there as well.
Committee, even if the motion passes, I will recognize Mr. Gentry for comment after the motion, okay? Further discussion on the motion? Seeing Representative Hardaway.
Thank you, Mr. Chairman, and I'm going to vote no because I believe that when our citizens show up, they need to be heard. The explanation on why the judge is not here, it really doesn't ring true, and I just don't see inconveniencing the citizen who is here and understood what this hearing was all about, and yet the judge didn't understand. I don't get that. I'm going to give the benefit of the doubt to the citizen and vote no so the citizen can be heard. Thank you.
Thank you, Representative Hardaway, and I share your concern, but we do have a motion on the table in a second. Further discussion on the motion? Okay, Clerk, would you call the roll as to the Senate, and to remind the members, the motion is to roll this or postpone consideration until the next meeting of the Joint Government Operations Committee.
Senators Bell. Aye. Bell votes aye. Bowling, Crow, Jackson, Kyle, Pody. Aye. Pody votes aye. Powers. Aye. Powers votes aye. Rose. Aye. Rose votes aye. Chairman Roberts. Aye. Chairman Roberts votes aye. 5 ayes, Chairman.
House members, all in favor of the motion, please say aye. Aye. All opposed, please say no. No. Motion passes. The matter is postponed until the January meeting of the Joint Government Operations Committee. Mr. Gentry, you're recognized for 5 minutes to comment on the rule.
My name is John Anthony Gentry. I'm a CPA and a candidate for state senate, and I'm an advocate for judicial reform and to restore constitutional rights of the people. I'm asserting my right to address the powers of the government pursuant to Article 1, Section 23. My address today is on point and less than 10 minutes. And to stop my address would be a violation of my Article 1, Section 23 right. This matter before the body is to approve the rules for the Tennessee Board of Judicial Conduct. The fact of these constitutionally repugnant rules that I will lay bare momentarily are prima facie evidence that this agency's intent is to conceal and protect judicial misconduct and criminal conduct, and why our founders prohibited second offices of trust to prevent corruption, and why we cannot have the fox watching the hen house, and why the judiciary is incapable of self-government and self-oversight. These rules evidence why this agency is repugnant to our Constitution and Republic, and it must be abolished, and why we must restore the check of one branch over the other and power and return the right of the people to petition the legislative house. Rule 0102, subparagraph 1 and 2, chair and vice chair of the board, election or removal, both are to be chosen from the members of the board. According to the Tennessee Board of Judicial Conduct's website, members of the board include Judge Gay, Judge Brigham, Chancellor Atherton, Judge Bray, Judge Carter, and Judge McCullen. These judges and chancellor are members of the board already holding prohibited offices of trust in violation of Article 6, Section 7, and they cannot either be elected to chair or vice chair as a further prohibited office. What is an office of trust? Citing a treatise on the law of public offices and officers from the year 1890, Section 16, Office of Trust, an office whose duties and functions require exercise of discretion, judgment, experience, and skill, is an office of trust, and it is not necessary that the officer should be handling public money or property. Citing Eliot's debates, James Wilson, Pennsylvania Ratifying Convention, December 4th, 1787. The Incompatibility Clause, and that's prohibited second offices, seeks to prevent corruption by ensuring that the mere acceptance of an office officially destroys the end to which it was offered. Citing Cornell Law Review, 1984, one person, one office. The Incompatibility Clause was motivated by worries about British-style corruption. The framers did not perceive it as having much to do with the separation of powers doctrine. Clearly, the Tennessee Board of Judicial Conduct is an office of trust, and our Constitution prohibits judges from second offices of trust. No judge shall hold any other office of trust or profit under this state or the United States. Neither the chair, vice chair, nor any members of this agency can be members of the Tennessee Board of Judicial Conduct due to the Incompatibility Clause. Since they swore oaths to uphold the Constitution, these judges and chancellor members are in violation of their oaths of office, and they are in treason to the Constitution. Rule 0102, subparagraph 3 states that the chairman shall preside, and I quote, preside, at all meetings of the board and at, I quote, trials, which brings me to the next point. Rule 0103, subparagraph 1, confidentiality, which states that matters that come before the board are confidential. Presumably, if a judge is presiding over a trial, then this board is a court. And pursuant to Tennessee Constitution, Article 1, Section 17, all courts shall be open. But this agency, with its unconstitutional rules, operates in the dark to preserve false public trust and to conceal the misconduct and the criminal conduct of corrupted members of the judiciary. In the Supreme Court of the United States, 1980, Richmond Newspapers versus Virginia, the crucial prophylactic aspects of administration and justice cannot function in the dark. No community catharsis can occur if justice done in a corner in any covert manner. It is not enough to say that the results alone will satiate the natural community desire.
15 seconds, Mr. Gentry.
A result considered untoward. All right, I'm going to skip this. The last part of this, and I'm going to cut to this really quick because it sounds like this thought body is going to violate my Article 1, Section 23 right to address the powers of the government. The last part of this, they say they're going to keep all relevant documentation, which allows them to conceal evidence. They say that transcripts don't need to be included, which is the proof of the criminal conduct. And this agency explicitly, with that rule and how they conceal evidence, and they keep it from the permanent electronic record, and they destroy the physical record within just 1 year after final disposition, is clear evidence that this agency conceals the misconduct and criminal conduct of the judiciary. April 23rd, 2019, the Board of Judicial Conduct issued an interim order suspending Judge Woodrow Adams. Is his pay suspended? I don't know.
Mr. Gentry,
he was indicted by a grand jury on a felony charge of child rape.
Thank you, sir. Are there any questions or comments from the committee? I just want to say this. Thank you for coming down here, okay? I think what you're saying is that judges should not be allowed to serve on this board. It's contrary to the Constitution. Is that correct?
It is repugnant to the Constitution.
Okay.
And thank you for that question. It is repugnant to the Constitution, but not only that, these rules that they're putting forth are to conceal the misconduct of the judges out there. This agency has long been concealing the criminal conduct of judges, causing great harm to the citizens of this state, and it needs to stop.
Mr. Gentry, thank you. So have you asked your representative and your senator to request an opinion from the Attorney General on this issue?
The Attorney General has responded already several years back. It was provided to me by Senator Roberts, and their opinion was only that they're not violating the separation of powers doctrine, which I disagree with completely. The Attorney General avoids the question, as attorneys commonly do when they don't have an argument. They ignore the question. And the question is, are they holding prohibited offices of trust? And the answer is absolutely, yes, they are.
Okay, question. Have you requested your representative and your senator to in turn request an opinion from the AG?
I have approached both houses in their entirety in a petition of remonstrance filed on the first day of last session.
Mr. Gentry, please answer my question.
Well,
have you asked your representative and your senator to in turn request an opinion from our Attorney General on this issue?
I responded back to Senator Roberts when he sent that to me, specifically to my representative and my senator. I have complained to them in a petition of remonstrance. So to answer your question, yes, I have, and my petition of remonstrance remains ignored in violation of my constitutional rights.
All right, Mr. Gentry, then I would suggest you hire a lawyer and resort to the courts. I'm not saying that your issue has merit. I'm not saying it's frivolous either. I've studied some of your documents. It might have merit, but I think that you need to hire an attorney if you want to proceed with this and try to invalidate the Board of Judicial Conduct.
I would not hire an attorney to tie my shoelaces, to be quite honest with you. I represent myself quite well in court, and I am addressing this through a writ of mandamus in Chancery Court now before the Court of Appeals.
Any other questions from the committee? Seeing none, thank you, Mr. Gentry. Committee, we will meet again on January 13 for Judiciary and Government Subcommittee on a sunset hearing. Thank you, committee, for your.
And just thank you very much, Mr. Chairman.
Thank you, Mr. Gentry.